Welcome to the presentation on structuring your law practice, where we'll talk about for-profit options, nonprofits, cooperatives, and more, all with the help of chocolate cake. I'm Janelle Orsi from the nonprofit Sustainable Economies Law Center in Oakland, California. I'll often use our organization as an example in this presentation. I've also had a small private law practice for about 10 years. And I like cake for the purposes of explaining legal concepts. So here's a cake. And I use the cake to examine the choices we make when we structure our law practices. So think of a cake as the entity and the icing as the tax status. An entity is something you form according to state statutes, and I'll mostly reference California cake law in this presentation. And then the tax category is the variety of icing that you elect at the federal level, usually to achieve a particular tax benefit. Almost every entity has multiple choices of tax category, so you can really mix and match cake and icing. And then there's infinite possibility for the ingredients that you choose in your internal financial governance and operational structures. Many times I have watched lawyers confuse their clients by trying to explain entity structure in a way that conflates the choice of entity with a tax status and with other considerations like governance. They'll say, here are your choices. Partnership, LLC, S corporation, C corporation, cooperative, and that's kind of like handing you a smashed piece of cake. What they might not explain is that a partnership can actually be structured as a cooperative and it can be taxed as a corporation. So entity tax and internal structure are really three separate considerations. So let's start with the basics of entities. If you start practicing law, so you take a client and you charge them money, then you will instantly become a sole proprietor. It's like, poof, there you are. You're your own entity, and you didn't even have to lift a finger to form that entity. Maybe your mother did, but in any case. Now, a partnership, something kind of similar happens. So if you and a friend start practicing law together, even if you don't lift a finger to form an entity, then you will, poof, have formed, by operation of the law, a partnership. And if you do this, however, you are probably going to want to do the work to formalize it. So first thing is a partnership agreement, which is essential to make sure that you and your partner are on the same page about how you work together and make decisions, allocate profits and losses, etc. You'll also need to get a separate tax ID for your partnership and file a tax return for it. So there are formalities, even though you can sort of accidentally form a partnership. So beyond sole proprietorship and partnership, the easy ones, what other choices do you have? Well, in most or all states, there are limitations on the kinds of entities that professionals can form. So in California, for example, lawyers can't form a limited liability company to practice law, but they can form a professional corporation or a limited liability partnership. But in many ways, these aren't exactly types of entities. They're more like add-ons that you put on existing kinds of entities. So for instance, a professional corporation can be a run-of-the-mill corporation that has added requirements that limit ownership to a category of professionals like lawyers, and that helps to preserve the integrity of the profession. One reason I emphasize that is that these add-ons can be put on other kinds of corporations, and in recent years we've seen across the U.S. new kinds of entities emerge in response to a desire to build social and environmental purposes into the charters of corporations and to alleviate fears of shareholder lawsuits that could result from that. So in California, we have benefit corporations, we have social purpose corporations, and in most or potentially all cases, I'm pretty sure that lawyers can still use these entities and still have that professional add-on of being a professional corporation. Of course, there are other entities that have always let you build in social purposes, and that's nonprofits. In California, there are potentially two types of nonprofits you might form. A nonprofit public benefit corporation, which requires that the public purpose or charitable purpose be baked right into it, or nonprofit mutual benefit corporation, which can be formed for any lawful purpose, and so they're quite flexible. Interesting note, I've tried to research what it means to have a public purpose, and any of the definitions and statutes and case law, they're really vague. So it's possible that no one really knows what a public purpose is, although I'd argue, and this is just my opinion, that there should rarely be any other purpose to a law firm other than serving the public. I don't really know if that will fly, but in any case, that's my theory, and that's why I think any law firm could be a nonprofit public benefit corporation. What I like the best about nonprofit corporations is the basic feature that prohibits the distribution of profits to private individuals. So you can pay employees reasonable salaries, of course, but you can't pay profit dividends. And I like this for reasons related to what I'll say later, which is that I think that profit extraction, or the extraction of rents, in the legal profession is a major problem, and it's creating scarcities of access to legal services. I'll be saying more about cooperatives later, but for now, I'll note one interesting question related to choice of entity, which is that in California, there's a type of corporation called a cooperative corporation. In fact, many or most states have such a thing. But can you form a cooperative corporation to practice law? Well, that's a hard question to answer. Because in California, the LLC law says that certain professionals may not form an LLC, but the cooperative corporation law fails to mention anything about that. So in order to get professional corporation status, we do know that you have to form a general corporation, sort of conventional stock corporation. But professional corporations are not the only corporations that can practice law. And we know this because nonprofits can also practice law. So I've never actually seen anything explicit that says a cooperative corporation cannot practice law, and a way to find out would be to form one and register to practice law with the California State Bar, and then see if they can find any basis on which to disapprove that. So forming an entity is generally something you do by filing papers with the Secretary of State, and then often, depending on the entity type, you may also need to register your entity with the State Bar in addition to that. So registering gives the State Bar the opportunity to make sure that the entity is practicing law or that it's controlled by lawyers. And of course, the idea is to ensure that no one else can control the independent professional judgment of lawyers. They want to see that the shareholders and the directors of the corporation are only lawyers. And of course, the intention behind all this is to preserve the integrity of the profession, independent judgment of lawyers, and the theory is that if non-lawyers have the power, or if they stand to profit from the work of a law firm, then we're opening up the possibility that they could pressure lawyers to do unethical things in service of making profits. And it's worth stopping for a moment to acknowledge the problem with that assumption. And just because someone is a lawyer doesn't mean that they have instantly attained a magically incorruptible mind that will always make decisions in the best interest of clients and never in the primary interest of profits. No. There are law firm partners in the United States earning millions of dollars per year, and many of my former law school classmates have told me about the pressures that they feel working in big law firms to, say, pad their hours or offer clients services the clients don't even need. And ironically, in recent years, we've even seen a move toward having more non-lawyers serve on the board of trustees of the state bar associations, which is basically recognizing that actually, if we let lawyers, only lawyers, make decisions about what lawyers do, then we could in fact end up with lawyers becoming too powerful and just feeding only the interests of lawyers. So having lawyers be the only owners of a law firm might actually be a disservice to society rather than a service. But in any case, there's also been a lot written and said about this. So mixing non-lawyers into the governance of the legal profession and into law firms could actually do a lot of good. So I suggest reading some articles about the history of multidisciplinary practice, or MDP, and what the different bar associations have considered or said about it. It's interesting stuff because the legal profession has actually really grappled with this question, observing, quite rightly, that legal services are often more effective when they're combined with non-legal services, provided, of course, often by non-lawyers. So a family lawyer, a family law mediator, a family counselor, they might be able to get together and form a business that provides incredible services to families, maybe serving them far more effectively than a lawyer alone could. And maybe we just need to embrace that more fully. Also interesting, nonprofits don't always have to register as law corporations with the state bar, which makes them ideal structures in which to do multidisciplinary practice. There have been kind of back and forth arguments about this over time, and a lot of nonprofit legal organizations have non-lawyers on the board, and they often combine legal and non-legal services. The issue was examined really closely in the context of a case called Tenderloin Housing Clinic versus Fry. in San Francisco. And that case, and that the Tenderloin Housing Clinic provides a lot of support services, which includes legal services, but also others to help clients find stable housing. And so in examining that, the state bar ultimately agreed that, well, nonprofits, they really do provide a lot of benefits to communities, and nonprofit corporations seem to be at much less risk of imperiling clients' interests, and therefore the bar hasn't taken the active step of requiring that nonprofits register as law corporations. Okay, a whole other consideration related to choice of entity is liability. Sole proprietorships and partnerships are the kind of de facto entity choices when lawyers start practicing law, but many lawyers choose to take that additional step to form other entities because they would like to have a layer of liability protection. Corporations, and generally any kind of company or partnership with the LL in it, which stands for limited liability, those will offer a liability shield of sorts. So here's how that works. It means that if your firm, say, borrows money and cannot pay it back, then an individual owner of your firm, in theory, will not be liable to repay that debt personally. In addition, if the firm causes harm through negligence or recklessness, then individual owners will, in theory, be protected from liability. The idea is that the firm and its owners are two separate things. And there's you, as an owner of the firm, and you can step back and say, look, it's not me who caused the damage. It's my company. My company is separate from me. And there's a lot of formalities that the companies are advised to adhere to in order to demonstrate that you do view the company as separate from you. And keeping a separate bank account and not intermingling funds, those are examples of some of the things you have to adhere to. But none of this is a complete liability shield, and here's why. Even if you maintain the appropriate level of separation, you could still be personally liable for the debts of the company because, especially if it's just you and maybe one or two other people, it's not going to be very easy to borrow money unless you each sign a personal guarantee of the loan. And furthermore, if you are personally negligent and you commit malpractice, you may not necessarily be personally shielded. Other individual members of your firm will be shielded, but possibly not you personally. So I've generally told people that the limited liability piece can be overrated, especially if you have good insurance to protect yourself, and especially if it's just you practicing on your own. But if you practice with other people, the liability shield will help you probably sleep better at night if you're worried that your partner's going to screw things up and cause liability. Other considerations for choosing an entity include the cost. In California, forming a limited liability entity like a corporation or LLP requires that you pay $800 a year in minimum taxes. I know that a lot of businesses form corporations early on and then they later regret it because $800 really is a lot of money, especially when you're a startup. Most other states are less expensive than California. Also, there are some formalities to weigh in your considerations, which is that corporations come with a lot of formalities, like you have to hold meetings, and well, you have to elect a board, and provide people with notice that there are meetings, and take minutes, and keep clear records, and all of that. Some people don't really have the patience for all of that. But these formalities are important, and respect the separation between yourself and your entity. Another consideration is whether you want to deal with the administrative requirements of being an employee of your own entity. So if you form a corporation, you may legally be its employee, even if it's only you. So do you want your company to issue wage statements and remit payroll taxes for you? Those kinds of formalities can just add on to the overall administrative burden of starting a firm. Of course, if you're a lawyer, maybe you like dealing with administrative formalities. I wouldn't say I like it, but I appreciate doing it so that I can advise my clients on how to do it. Another consideration in the choice of your entity is whether your state limits what you can call your law firm. If you have a great name for your law firm that's different than your own name, then it's possible the law won't let you get that creative in how you name your firm. In some states, there's limits on what you can name your firm, and it's possible in those states, like I think New York is an example, that if you're a nonprofit, you might have more latitude as to what you call yourself. So all of that was related to your choice of cake or your choice of entity. And now let's talk about icing or your tax status. And we'll do that with the help of Aunt Sam, who has graciously stepped in to replace Uncle Sam in collecting your taxes. So remember that I said becoming a sole proprietor is really easy. So is filing your taxes, because you don't even have to file a separate tax return for your business. You just need to file a Schedule C, which you attach to your individual tax return, and list your income and expenses from your business. You'll also need to file quarterly estimated taxes so that the IRS can get your money early and often, but that's a pretty simple process. A downside to being a sole proprietor is that all of your income is treated as self-employment income, meaning that FICA, which is the federal insurance contributions to things like Social Security and Medicare, those will be tacked onto your taxes, totaling usually a little over 15%. So if that sounds high, it's because you've probably been an employee and you're usually responsible for only half of that, and your employer pays the other half. If you form a partnership or any other entity than a sole proprietorship, be aware that you will have to file a separate tax return for your firm in addition to filing your individual return. So one kind of tax status is partnership taxation, which is governed by Subchapter K of the Internal Revenue Code. If you're a partnership, LLP, or LLC, your default tax status will be partnership taxation unless you file a form to elect corporate taxation, which I'll explain in a minute. But first, a couple things to note about partnership taxation. All of the profits and losses pass directly to the partners, and those are the people who will pay the taxes or deduct the losses on their individual returns, so the entity itself does not pay tax, which is often seen as a good thing. But a downside to all of this is that all of the income, all of it, is treated as self-employment income, meaning you'll be paying that 15% for FICA. Here's what's different about corporate taxation. There are at least two ways in which you pay yourself, which is, well, first you basically pay yourself a salary, and that has to be at least as high as a reasonable or market rate salary for your profession. And I've generally heard lawyers say that $90,000 is more or less the minimum. So for that salary, both you and your corporation will contribute to Social Security and Medicare because it's basically employment income. But beyond that salary, you pay yourself in dividends, and those are considered regular income, not employment income. It's like any dividend you might get from holding stock, and you don't have to pay into Social Security and Medicare. In other words, if you expect to earn more than, say, $90,000, corporate taxation could give you more money in pocket because you have a lower tax rate for the amounts above your salary. And it's always been really easy for me to remember this principle in corporate taxation because in law school I got a part-time job as an assistant to a solo lawyer who paid me $15 an hour. I was working hard, cranking out legal documents for that person, and one day that person mentioned that their tax person was encouraging them to form a corporation for their law practice. And at the time, I was like, what does that mean? Why form a corporation? But I eventually figured out that it was because this person was earning loads of money, made possible in part by all of the legal documents that I was helping to crank out. So by electing corporate taxation, this person could take a salary and dividends at a lower tax rate. So corporate taxation is really great if you want to capitalize off the labor of others and earn more money. So that was a moment in my life that really reinforced my desire to start a law practice so that no one could extract profits off of my underpaid labor. So there are a few subcategories of corporate taxation. Let's look at subchapter S of the Internal Revenue Code. Many small law firms elect S corporation taxation because you not only get that benefit that I just described, but the entity itself does not pay tax. All earnings and losses pass straight through to the shareholders who pay tax. And you won't see as many of the big law firms structured as S corporations because you can only have up to 100 shareholders and you can only have one class of share in an S corporation. So that's why big law firms are more likely to be C corporations. So a C corporation, which is probably the most common type of corporate taxation, because of those limitations I mentioned on S corporations, the downside of a C corporation is that the corporation itself pays tax. And then when the corporation distributes dividends to shareholders, those individuals pay tax again. In other words, there's double taxation in a C corporation, or with C corporate taxation. But double taxation, well, it doesn't sound ideal. It does enable you some more flexibility. So for example, you can decide when you pay taxes by deciding when you're going to distribute the dividends, rather than having everything just pass instantly through to you as a shareholder, which is what would happen with partnership taxation or subchapter S. So corporate tax rates are generally also lower than individual tax rates, which is useful for the money that you plan to retain in the firm and not pay out as dividends. So small corporations, they even have a tax rate as low as 15%. So there are benefits to C corporation taxation. So you always hear people talk about S corps and C corps. Almost no one talks about T corps, but that's because subchapter T of the tax code is for cooperatives, which are pretty unusual in the world of law firms. Many cooperatives, like food cooperatives and worker cooperatives, they pay tax under subchapter T, which I believe actually provides the most favorable tax treatment of all, because it combines the best of both S Corp and C Corp taxation. It allows for a combination of single and double level taxation, and you have the flexibility to more or less choose whether the entity or the owners pay tax and when. I don't know of any law firm taxed under subchapter T, but I don't actually see any reason why one couldn't elect to be taxed in that way. It basically means that you get the most favorable tax treatment, which is single level taxation, when you're operating on a cooperative basis, which the IRS has defined to mean that you operate democratically, which is one vote per owner, and that the owners are not capitalizing off of others' labor. So the earnings get distributed back to the owners on the basis of how much labor each put in, and then any money earned from the labor of others, if it's ever distributed to the owners, that would be double taxed. So how about the tax status of nonprofits? The most likely choices of icing for your nonprofit corporation are 501c3 and 501c4, which are categories of tax exemption in the federal tax code. In exchange for that really sweet benefit of tax exemption, nonprofits agree to thorough oversight by the IRS and transparency with the public. Both of these tax categories, they have to file Form 990 each year, providing detailed reports to the IRS and to the public about their activities, finances, internal operations, and so on. For the 501c3 icing, I've put sprinkles on it because the reason that a lot of nonprofits want to be 501c3s is that the donations to those nonprofits are tax deductible to the donors, and you're generally also eligible to get grants from foundations. So 501c3s, they have a list of allowable purposes, which includes charitable and educational, and those are the ones I believe are the most applicable to the practice of law, but there's a list of other purposes which include scientific, religious, fostering amateur sporting competitions, prevention of cruelty to animals, and a few others. In a minute, I'll go into greater depth as to what is meant by charitable in particular. So a social welfare organization, or a 501c4, does not come with the sprinkles, meaning that the donors can't take the tax deduction. But if your primary source of income is legal fees, as opposed to donations and grants, then the sprinkles really aren't that necessary. 501c4s, they still have that nice icing of tax exemption, meaning they generally don't pay taxes on net earnings. The benefit of being a 501c4 is that you can likely have a broader scope of activities than a 501c3 can, because you're not limited to serving a charitable class of people, which I'll explain in a minute, or advancing educational goals. You primarily need to show that you're providing a social benefit to a broad swath of society and not just operating to benefit a small group of people. 501c4 is often treated as a catch-all for things that don't quite squeak by into the 501c3 exemption. Both 501c3 and 501c4 come with additional oversight and the constraints on the purposes for which you can operate. So if you don't want any of those constraints, you can choose to operate without tax exemption, which means that the nonprofit corporation pays taxes on its net earnings just like a C corporation would. And if you think about it, that's not such a bad thing, because chances are you won't have a lot of net earnings built up over time because you're going to be spending it on salaries and other costs. And well, of course, you will want some net earnings so that you can build an operating reserve, but overall, paying taxes on that might be a fine trade-off in comparison to the added administrative and accounting costs of being a 501c3 or 501c4. One of your primary constraints as a nonprofit corporation is that you can't distribute out those net profits, which is a kind of a good constraint to have. You just reinvest those funds in serving your clients or lowering costs to your clients. So your choice of C3 or C4 or no tax exemption at all could largely depend on your business model and your expected sources of income. So if you think that you'll rely primarily on foundation grants and donations from people who can use that deduction, then the 501c3 would probably be the way to go. The tax deduction really won't matter to people who take the standard deduction on their taxes, which I think is between 40 to 50% of people, usually low to moderate income people who don't own homes, take the standard deduction, and therefore they won't really care whether their donation is tax deductible or not. So your donor base matters. Also, if you're charging for legal services, and if that's your primary income source for the nonprofit, then 501c4 or even no tax exemption could be easier to administer and could give you more flexibility in your activities than a 501c3 could. This unicorn is here as a way for me to emphasize that it's not that easy to get grants for the provision of legal services. I've been trying to do it for 8 years, and I've found that such grants can be pretty rare. A lot of people just think, they kind of imagine, oh, it's going to be easy to start a nonprofit and just apply for and get grants. But especially with the threats to cutting federal funding of legal aid, I think those grants could become even more competitive. That said, my organization, Sustainable Economies Law Center, is primarily funded by grants, but we do so much more than legal services. What I've found is that foundations fund us because they see us as a systems change organization. Legal services are just one part of our systems change puzzle, which we combine with education, policy advocacy, and movement building in order to have a deep social impact. So foundations fund us because they see our work as transforming food systems, scaling renewable energy, and innovating in realms of housing, land ownership, cooperative business, and so on. And by the way, I think there's a huge need for other organizations to emerge across the U.S. and take similar approaches to doing this work in communities everywhere. And I believe that work is quite fundable. And in fact, my organization has an incubator program to support other people in starting similar nonprofits. Now, here's a major reason you might want to choose 501c3 if you're worried about your law school loans. Working for a 501c3 nonprofit at least 30 hours a week for 10 years, that makes you eligible for federal loan forgiveness, if that federal forgiveness program sticks around, I should say. So law schools sometimes also have loan repayment assistant programs for alumni who work for 501c3 nonprofits. So this definitely shouldn't be the determining factor in the structure of your law firm, but it's definitely a bonus for 501c3s. So let's go deeper into the intricacies of 501c3 tax exemption. So if you're going to form a 501c3 law practice, you really want to have a solid argument that it's charitable or educational. And the way the IRS defines these two words is different than how you might be defining them in everyday speech. You really have to look at the history of IRS decisions, rulings, and guidance to understand whether your legal services will be considered charitable or educational. Charitable is a particularly tricky one. The IRS gives this list right here as a list of things it considers to be charitable. So that list helps, but then each of these things on the list have very particular definitions. So here's a little history of how the IRS has responded to the question of whether charging for legal services can fall legitimately under the charitable or educational purposes. So first we have pretty clear rulings saying that it's okay to charge a little bit, like a nominal amount, if the primary purpose of the organization is to serve low-income clients, and if the amount that you charge is based on the client's ability to pay. But in that same year, 1978, the IRS said that, well, the tax court heard a case of BSW Group, which was an organization formed to provide consulting services to rural-related nonprofits and to help research realms such as vocational skills, alternative housing, health delivery systems, environmental impact programs, and that kind of thing. The tax court ultimately decided that BSW Group wasn't eligible for 501c3 exemption, and instead they found that it was conducting an ordinary commercial consulting enterprise in competition with other commercial firms. As a lawyer who provides legal services to nonprofits under the umbrella of a nonprofit, I definitely find this case somewhat haunting and irritating. One implication is that if a for-profit commercial business provides a particular kind of service, then it becomes kind of off-limits for nonprofits. And we know that law firms have developed a highly commercial hue, but does that now mean that nonprofits can't provide the same services? And so I ask, why should we privilege commercial corporate capitalist businesses and make them supreme and allow nonprofits to enter that space only if those commercial capitalist corporate businesses have failed to enter the sector? I think our priorities are all wrong and that we should instead be questioning the deeply commercial hue of law firms. The court here actually said that the outcome of this case might have been different if BSW Group had proven that commercial consulting firms do not provide similar services in that area. But also irritating was that the court found it problematic that the consulting fees that BSW Group was charging were set just above at cost, meaning that a small operating reserve of $2,000 was left over after the consultants were paid. But this is silly. It's silly that the court would consider this problematic because building a small operating reserve is a necessary cost and a part of running a responsible business or organization. But what happened next? Okay, let's see. In 1992, the IRS issued a guidance document explaining when and how 501c3s can collect fees for litigation. This was helpful, kind of. They focused on public interest litigation, which is arguably a hard thing to define. The IRS said that litigation will be considered to be in the representation of a broad public interest if it's designed to present a position on behalf of the public at large on matters of public interest. The IRS goes on to explain that a little bit in the guidance, but it really remains unclear. So if you represent someone to sue their abusive employer, for example, then you're taking a position on behalf of the public that abusive employers should be held accountable and that employees should have and exercise remedies to that abuse. So how do you separate legal work that serves the public interest with legal work which does not? I think that remains a gray area and that there's room to move within it, especially in a society with so little access to legal services. I think providing anyone with access to legal services for any purpose can almost be said to be serving the public interest in some way. But then this guidance went on to be simultaneously very helpful and unhelpful on the subject of charging fees. It said that the fees you charge your clients can be set at cost as long as they don't exceed the cost. And that takes into account overhead, and that's really helpful. So you could almost read that to imply that you can earn what you need to provide these legal services and then not have to go out and beg for donations, except for, oh, wait, maybe lawyers and nonprofits will have to beg for donations because this guidance document also said the above, which is that the total amount of attorney's fees must not exceed 50% of the total cost of operation of the organization's legal functions. So are they saying that for any particular client, it's fine to charge what it actually costs, but as an organization as a whole, you must not operate at cost. Instead, you must strive to have a 50% deficit at the very least, and then go fill that deficit in other ways, like asking people to donate. But, if your organization operates to provide, say, legal representation to low-income landlords, hey, that's a real need that needs to be met in society, though it's definitely not a warm, fuzzy thing to do. And so good luck trying to get donations to fill that 50% deficit the IRS wants you to have. At least that's how I'm reading this case. I hope I'm reading it wrong. But if this were the final word from the IRS, we could do two things with it. One, we can push back because it's kind of ridiculous and contradictory. Or two, we can do other legal work that will motivate the public to donate to us. It can be hard, but my organization definitely meets this 50% rule because a lot of our legal work is supported by donations. I don't think that most legal services will attract donations, though. So fortunately, we can rest easy knowing that this was really just a guidance document from the IRS, and they even said, well, This is just a guidance document. There might be other situations that we're not thinking of. And what I'm seeing now is more recently, I think the IRS decisions we're getting now are basically ignoring this guidance because then came the amazing Rachel Armstrong, who is the founder of Farm Commons in Wisconsin. And Farm Commons provides education and legal services to farmers. So she applied for tax exemption, and then the IRS wrote back and said, "You need to explain how providing legal services to farmers is considered tax exempt under 501c3. So Rachel explained it all right. She responded to the IRS with a letter that read more like a treatise on rural poverty and economic deterioration, and also on the failure of the legal profession to provide for the legal needs of farmers. She cited that only 16% of farmers have access to attorneys. And she also wrote a lot about the positive economic development impacts of supporting farmers, and especially of supporting women farmers and organic farmers, because they have direct impacts on improving economic conditions for society as a whole. So it's a good read, this response she wrote to the IRS, and she made the charitable argument from multiple angles. And she basically said, look, not all of my clients are going to be low income, and I'll sometimes be charging them the full cost of doing this work. The IRS granted Farm Commons tax exemption without another word, so we don't really know which of her arguments swayed them, but it worked. It's worth noting that Rachel also made the case that some of her client work qualified as educational because she chose some clients on the basis that the work she did for them would help her develop educational resources like sample documents, and she makes a very good point, which is that you really can't teach someone how to do something without having done it yourself. So serving clients enables her to learn about the intricacies of how farms and farmers actually work, so that she can then provide responsive legal services and legal resources to them and then share those resources with others. So then came, just a few years ago, Open Legal Services in Utah. Here are the basic points that they made in their tax exemption application, which is that there's a whole middle sector of society that doesn't qualify for free legal services, and they can't afford a market rate lawyer. They also pointed out that the resulting large number of people without representation was putting an incredible burden on the state and on the court system. Open Legal Services said that they provide family law and criminal law services to low and moderate income clients, defined as up to 400% of poverty level, and that they do so at a sliding scale with rates between $40 and $125 per hour. So they also slipped in something pretty bold, which was, while higher income clients are not the target of the organization, clients who are able to pay a full fee will not be turned away. So I don't know if or how the IRS scrutinized all this, but what I do know is that Open Legal Services was granted 501c3 tax exemption. And I believe that if that represents a shift in how the IRS is viewing legal services, then arguably this opens the door to fill that entire gap in access to legal services by forming large numbers of 501c3 law firms. I mean, the ABA has said that the legal needs of the middle 70% of society are largely not being met because those are the people who can't afford legal services. And that, to me, feels like a call to 501c3 nonprofits to emerge and step up and start to fill that gap by serving those moderate income clients. Generally, we can argue that a growing number of people are falling into what the IRS generally defines as a charitable class of people, which includes the poor, distressed, and underprivileged, as they call them. I believe we can pretty safely use twice the poverty level as our threshold for what the IRS calls poor, quote unquote, because I think I've seen this measure used in rulings related to affordable housing. But if that's the case, 1/3 of the population is poor, and we can capture an even larger percentage if we use housing price data to argue that, well, for example, in Oakland, due to the percentage of people's income that goes toward housing, people have very little disposable income left. So you can argue that an even larger percentage are quote-unquote poor. And as for how we define who is distressed, well, perhaps that should include anyone who can't access legal services, because that's really distressing. Access to the legal system is essential to our functioning as in a society, and it's quite possibly essential to individual survival in some cases. And the very fact that lawyers are unaffordable to most people is probably making most people distressed. With all that said, it's important to keep in mind that if you are going to form a nonprofit and go the 501c3 route, then you're still treading into slightly uncertain legal territory, especially if you aren't serving the lowest income clients in a more traditional legal services setting. But it's worth pushing these boundaries, and I would encourage people to do so because the number of people in society who don't have access to legal services, it's a lot. And because the tax exemption can really make it a little bit more viable to have lawyers fill that gap. So if you're going the 501c3 route, like I said, first ask whether your activities are what the IRS considers educational or charitable. Again, this is not always easy to determine, but I'll explain how we've analyzed it at Sustainable Economies Law Center. And it wasn't just a determination that we made at the beginning of our organization. It's a constant inquiry about really every one of our activities where we have to ask questions like, does serving this client have a substantial causal relationship to advancing our charitable purposes? Or is it going to advance it only just a tiny bit? Or is this activity larger in scope than what we actually need to do to advance our goals? So here are some examples. Here's how it plays out. When we provide pro bono services to low-income clients to help them, say, start a worker cooperative, we consider that to be charitable primarily because those clients are low income. Though we also know that they're advancing local economic development and creating jobs locally. So there's kind of two bases on which it meets the standard for charitable. Similarly, when we have clients who are mixed income, and if it's a little less clear that we're directly serving a charitable class of clients, then we really look at the work that those clients are doing. Are they helping to alleviate distress for a broader sector of society? In other words, we consider it charitable. Not that we really actually like using the word charitable, but anyways, we consider it charitable to provide low-cost legal support to organizations that are alleviating economic distress in our neighborhoods, basically. So sometimes we take clients for the primary purpose of creating educational resources, kind of like what I mentioned that Farm Commons does. The clients help us to learn what communities need, and then we craft a legal document or a legal tool in conversation with those clients, which can then be replicated by others. So it makes it an educational tool with broad community benefit. In this example above, we're drafting bylaws for a very innovative land trust, and that'll be very useful to other land trusts. But then let's say, after we draft that first very innovative land trust bylaws, if we become kind of a factory farm producing lots of bylaws for lots of land trusts using that exact model, at this point it's hard to argue that we're doing this to serve educational purposes. We may still be able to argue that it alleviates economic distress and promotes economic development, but the marginal returns for education are much smaller after we did our first bylaws. So if this is just for educational purposes, the activity now has become larger in scope than what's needed to advance the educational purposes. So that's kind of how the analysis happens. And of course, if we start charging market rate legal services for just run-of-the-mill legal transactions for typical businesses, then we'd probably treat that as what the IRS calls unrelated business. And then we would pay unrelated business income tax on it. And note that 501c3s can have unrelated business activities and pay taxes on them as long as those activities are insubstantial in relation to all of the related activities. So related, by the way, it doesn't just mean that it's related to your tax-exempt purposes. It also means that it's substantially furthering your tax-exempt purposes. So everything you do, almost everything you should do should be related, and a little bit of what you do can be unrelated. A really good way to find out whether the IRS will consider your work eligible for a 501c3 tax exemption is to apply by sending in Form 1023 and then describe what you're going to do and how you're going to do it, why you do it, and how you're going to charge fees. The IRS could come back and ask you questions. They often do this. And those are often quite helpfully leading questions that kind of hint at what the IRS is considering problematic about your application. And it gives you a chance to kind of reshape your plans a little bit and then help satisfy them that your work qualifies. And if they do ultimately come back and say, no, your activities are not tax exempt under 501c3, then your fallback plan can be to go for 501c4 tax exemption, which means that you're probably not going to access foundation grants and tax deductible donations, but at least you don't pay tax. By the way, one reason that a lot of people shy away from starting nonprofits is that they don't want a board of directors to essentially be their boss. It's true that a board will likely have to approve your salary and oversee your activities, and they could even have discretion to fire you, but otherwise it's important to keep in mind that a lot of decision-making in most nonprofits is delegated to staff. Assuming that you're the person who's best positioned to lead strategy, management, and the daily work of your firm, then the board will likely be relatively hands-off and more simply provide oversight to ensure that you're complying with the law and focusing on your mission. By the way, you can also consider having both a private and a nonprofit law practice side by side. I personally still have a small solo law practice on the side while the nonprofit is my primary gig, but what I like about keeping that small solo practice is that I have the flexibility to take whatever client I want and on whatever terms I choose. And so I often barter with my clients. I get paid quite often in food. I can also take clients who are high risk, or I've taken wealthy clients. I've taken friends as clients just to help them out. These are things that would be harder to do from within my nonprofit. But with a nonprofit, I'm able to look at the broader needs of society and strategize about systems change and access the resources to do that work in a variety of ways beyond just legal services. So if you're going to practice law under two entities, it's great. But the most important thing to keep in mind is a very clear separation between the two entities so that clients know which entity is serving them, and that they're not misled, first of all. But you also, if you have a nonprofit, you really need to make sure that the nonprofit is operating or that it's not operating to send business to your for-profit, because that could create inappropriate private benefit. And so Sustainable Economies Law Center, we even have a whole committee focused on making sure that we're careful about all of these things. So overall, doing both a private practice and a nonprofit practice can be a really rewarding way to be a lawyer. So far, I've explained the cake and the icing, which is the entity choice and the tax status. But apart from all of those considerations, there's a lot more to think about when it comes to the ingredients you mix into your structure, the financial governance and operational considerations that you put into the design of your law firm. And I think it's these ingredients that will really drive the experience of the firm for you and your clients. I'll start by giving an example of B corporations, because while this sounds like it's a type of entity or tax category, it's actually neither. B Corp is a certification that an organization called B Labs gives companies if the companies meet certain standards for social and environmental responsibility. So by the way, many states have created a kind of corporation called a benefit corporation, but that's actually different than the B Corporation certification. Two different things. You can choose a conventional entity and tax status and still get certified as a B Corporation if you build in socially and environmentally responsible practices and policies. In your operational, financial, and governance choices, you can also build in essential elements of a cooperative. Note that the word cooperative means different things to different people, and that's why I've tried to draw it to look like an elephant here, to reference the story where a group of blind people come upon an elephant and each feels a different part of the elephant, and they each conclude that it's something different. So similarly with cooperatives, to some people it's a tax category under subchapter T, and of course almost any entity can choose cooperative taxation. To other people, a cooperative is a type of corporation that you can form under state law. To others, regardless of the entity or tax status, it's an organization that adheres to certain principles of democracy, equity, inclusivity, and so on. But I'll just boil cooperatives down to two key features by comparing it to regular businesses. So in a typical business, the more money you put in, the greater your share of the votes. So corporate shareholders get votes based on their share ownership. And also, the more money you put in, the greater your share of profits. In other words, the rules of conventional businesses are that money buys power and money buys profits. But if you don't want to live in a world where money rules everything, a cooperative can be a good option, because people get the power and people get the profits. Each person gets one vote, and each person generally gets a dividend based on either how much they worked for or how much they purchased from the cooperative. If you think about it, you can build principles of democracy and equity into almost any entity structure by adopting certain things in your bylaws and policies and practices. In a minute, I'll explain how the Sustainable Economies Law Center built a cooperative structure into a 501c3. But first, let's stop and talk about a few other words that sound a little bit like cooperative. The phrase law collective, or perhaps law collaborative, could sometimes refer to arrangements where multiple independent lawyers, many of whom might be solos, or some could be small law firms, they come together to provide a form of mutual support to one another, or maybe to advance a common vision. They might share office space or have a shared website that links to their individual websites. So for example, the Oakland Law Collaborative is a group of attorneys and organizers and legal workers supporting each other and sharing resources in doing social justice legal work. The lawyers involved, they still have their own private practices, but the collaborative supports them to advance their common vision. You'll see that I included an asterisk here in this graphic because anytime lawyers do a joint marketing or anytime they share offices, it's really important to tread carefully so as not to confuse the public and make people think that you're all part of one law firm. The phrase law collective does have a particular meaning adopted by a movement of social justice-focused lawyers who usually work in democratic organizations in direct collaboration with non-lawyers and social movements. So law collective, it has no definition under the law. It's not an entity or a tax status, but you could explore it as an approach to weaving certain values and practices into your work. So at my nonprofit, the Sustainable Economies Law Center, we are a nonprofit cake with 501c3 icing. But on the inside, one of our key ingredients is that we've chosen to be non-hierarchical as a staff. Everyone makes the same salary, which is $53,650 per year, which is set according to a living wage index. And we distribute the governance throughout the staff. One reason we chose this is a recognition of the deep social harm caused by the adoption of fixed hierarchical structures. We know that at the top of most hierarchies, people in power are disproportionately white and male, and that situation is really not going to be equaling out anytime soon. And in the legal profession, this is particularly a problem. It's the least diverse profession in the U.S., and if you look at the trends over time, it's actually getting less diverse racially because the proportion of people of color in the U.S. is growing much more quickly than it is in the legal profession. So the profession is becoming less representative of U.S. demographics. So at the Law Center, we created a structure that spreads power and equalizes pay. In recognition that inequality in the U.S. is getting worse, the racial wealth gap is widening, the legal profession is becoming less diverse, so the least we can do is not make it worse. And as a society, we just can't wait any longer to start making radical changes. I also think about the problem of hierarchy when it comes to the question of serving the best interest of clients. Because what we've seen and what I've heard from so many of my peers who work in hierarchical law firms is that there's still a strong tendency to prioritize profits over the best interest of clients. And when you have people in positions of power who can pressure other people to focus on profits and pressure them to bill more hours and coerce clients into buying services that they don't need, it's really much harder to keep the best interests of clients in mind. And so we end up with the same problem that we're trying to avoid by keeping non-lawyers from co-owning law firms. People who have power can pressure people who don't have power. And they pressure them to make choices that don't serve clients. And so we really need to put each person in a position of power and responsibility and accountability to clients. So what does that look like? What does it look like to have a non-hierarchical law firm? A lot of people have a hard time picturing it, wondering how you control what happens if there's not really a clear person in charge or a place to steer the law firm from up top. When you remove a hierarchical chain of command, you don't exactly replace it with something flat, like you see here in this picture. There's still differences in power in our organization, but the power is spread throughout the organization in all kinds of arrangements. Our org chart looks like a collection of about 25 overlapping circles. You could say that we're polycentric, meaning we've created many centers of power, so power just lives all over the place. So how do we make decisions? A lot of people picture that we must sit around in circles and make all decisions with complete consensus. And of course, people often picture that that's a slow and tedious process. Well, it can be. It could also be a wonderful process. It really varies. But this is actually not what we do at the Law Center. In our organization, our work is distributed into 25 different small groups of people, or circles as we call them, and each has a lot of autonomy. And then within each circle, everyone has defined roles, and so each person has a lot of autonomy. Most decisions are just being made by single individuals, but always in the context of gathering feedback from peers. So sometimes we call it worker self-direction. It could also be called peer-guided self-direction, because really each person is self-directed, but with constant feedback from peers in every circle where we work. And what allows us to work is having a very transparent organization where people are highly accountable to each other and where the group can intervene when things seem to be going off course. I think self-direction is particularly important for us as legal professionals because we need to exercise the independent judgment required of us by the rules of professional conduct. At the same time, a system of peer feedback is incredibly valuable in providing the best possible services to clients. So my coworkers give me all kinds of ideas and information, which enables me to better provide services to clients. I recommend this book, Reinventing Organizations, which profiles businesses with similarly decentralized structures, and I think it's very much worth applying this model to more law firms. So I've talked a bit about governance and operational structures of law firms, but what about the financial structures of law firms? I think this matters immensely because it's so common for firms to implement pay hierarchies and create a system of hiring associates who work for fixed salaries while generating limitless profits for partners. At the top, at the top law firms in the United States, the average partner makes $1.5 million per year on average, while the law firm associate has been found to be the unhappiest job in America. And this is exactly the kind of behavior and the business model that results in the wealthiest 1% controlling half of all of the world's wealth. And also, meanwhile, wealth inequality between black and white households is both shocking and getting worse. So white households on average have 13 times more wealth than black households, and we're basically watching race relations collapse across the United States. Wealth inequality and racism are explicitly issues that the legal profession is obligated to address because in exchange for the incredible privilege of having a monopoly on the practice of law, lawyers were given certain responsibilities related to the preservation of society, ensuring justice, improving the law, improving access to the law. But what has the legal profession done with that monopoly? What we've done is almost the opposite of what we were supposed to do. Many lawyers treat law practice as if they're playing a game of Monopoly, and they charge very high rent for access to the law because they have the power and privilege to do so. The preservation of society and the administration of justice are not served by positioning law firm partners to earn $1.5 million per year. Lawyers make these kinds of profits by maintaining and exploiting the scarcity of access to legal services. Lawyers reinforce those scarcities by making law even less accessible, making it hard to comprehend, hard to afford, and so on. But law is almost essential to life, almost as essential as water, because if you want to survive in a civilization, you need access to the law. But it's really like access to the law has been taken away and stored up in a tower where people just can't access it, and the society will devolve into chaos if this gets much worse. So creating and maintaining scarcities is how lawyers charge rent. The concept of rent is important for the legal profession to confront. So rent is the amount that lawyers get away with charging that's above the actual cost of providing services. A lawyer doesn't need to charge $600 per hour to make a decent livelihood. Lawyers could probably earn a great livelihood charging even $100 or $200 per hour. But lawyers charge more because they can. But because the primary purpose of the profession is to serve society, I think that rent has really no place in the legal profession. Of course, I don't actually believe we can succeed in prohibiting members of the profession from charging rent because the models of business are so entrenched and they're controlled by people with a lot of power and money. But what we can do is at least two other things. One is to begin to take away that monopoly. And then two is to eliminate the scarcities that enable lawyers to charge rent in the first place. In the bigger picture, I believe we can build a solid case against the legal profession, arguing that the monopoly is no longer legitimate. At the very least, we can use legislation to start carving out more legal areas where non-lawyers can provide legal advice and legal services. But thinking for a minute about the history of the legal profession and legal system, in the 1800s, bar associations formed and started lobbying, and they were granted a monopoly on the specific activity of providing legal representation in courts. But after that, somewhere along the way, lawyers managed to persuade courts meaning that it was kind of an inside job, they persuaded them to give lawyers a monopoly on giving legal advice and preparing legal documents. But that was before the U.S. had this giant explosion of new laws. So when lawyers laid a claim to a monopoly on the provision of legal services and the provision of legal advice, that was before the vast majority of statutes, regulations, and administrative agencies even existed. Now that we're swimming in basically a sea of laws, do lawyers still have a legitimate claim to being the only people who can help us with it? Regardless of what we think about or what we do about challenging the legal profession's monopoly, there's still a lot that we can do to build alternatives to the conventional law firm business model that creates scarcities. I think that the choices we make in structuring our law practices can make a huge difference. And I believe that we'll make the biggest difference by using structures that prevent rent extraction, so using nonprofit corporations, and then implementing participatory, democratic, and non-hierarchical structures within our law firms so that we empower every staff member to be fully responsible to the needs of clients and communities. So it's not coincidental that my own organization, the Sustainable Economies Law Center, is a democratic, non-hierarchical, nonprofit law firm. It's that I believe that those are the basic elements that offer our best hope for turning law and our legal system into what they really should be and what they should really have always been, which is a commons that's open and accessible to everyone.